Morning. Then I had a good morning all. Here is one announcement. The Chief Justice of Gauhati High Court is visiting this week, tomorrow, and day after. And on account of his maiden visit, Bar would like to hold a small short reception at 1 day tomorrow. So I request all the members to be there. Inform your friends that we should have a good reception. And if the members are not present, then it will be embarrassing for us. Right?
Lordships.
Yes.
Lordships, I beg to mention item 24 and 25. Lordships, here I've been instructed to appear for respondent 9 and 10, Lordships.
Yes.
So, Lordships, I need to. Lordship. Lordships. Lordships. Read up to 12, Lord.
Because you are doing Repealed 7.
I'm doing Repealed 7. I'm for appellant. But in read up to 12th of 2024, that is item 24. I have instruction to appear for respondent number 9 and 10.
Okay. So what do you want?
Lordship, is the material come out on 17th of July, Lordships. Since the Again Council has some difficulties this month.
Lordships, in item 24, the note 1 to entry, I've been informed that's still.
Let us see the file.
This one.
Why is it coming? Everything is not complete.
No, actually, this item 24, it's a fact that the lead to appeal was granted. Or else initially it was only item 25. So that, yes, it was,
Orders.
it has been admitted and would have been tagged together.
Okay.
Item 25 was in the
The applicant for the applicant?
Yes, Richard. For item number 24, I'm for appellant.
Okay.
Yes, Richard.
What name is your good name, please?
Theatrical.
Oh, Learned Counsel for the applicant in the week April 12th of 2024. Mr. Fosiko. Learned Counsel enters appearance on behalf of respondents 9 and 10 and prays for some accommodation. Stop. Accordingly, list matters. In the meantime, await service reports on the respondents 1, 2, 3, 6, 7, and 8 in read April 12th of 2020. List the matter on 15 July.
It's a 24th.
You want it on 24th?
Yeah, please, my lord. I beg to mention item number 14. Since the counsel for the appellant, Mr. Sentiang, is in bereavement, case may be listed after 2 weeks.
It is submitted to
Lordship, in the meantime, this honorable court may direct the registry to prepare a paper book.
Paper book is not ready.
No, no, Lordship.
Pick up the file. LCRs have been received. Registry is directed to prepare the paper book and list the matter after completion of the paper book.
Obliged, my lords.
Nabbis, Lordships. Lordships, I beg to mention item number 7, Lordships. Here for a sole respondent.
Yes.
Lordship, today is come up orders since the sentence is 10 years and above. So as per the Gauhati High Court rules, it was placed before this honorable court division bench. Lordship, paper book is also ready. And Lordship, if can be fixed for hearing, Lordship,
Yes.
in the usual course.
On request made by the parties. Paper book is ready.
Yes,
Lordship, paper book is ready.
You have received the paper
Yes,
book?
yes, Lordship, we have received. So
On
hearing
request
for
made
in the
by the
usual
parties.
course.
List the matter for hearing.
Highly obliged,
Has it been
Lordship.
admitted?
I think not yet, Lordship. Maybe can be admitted.
Okay.
Not yet much.
Heard Mr. K. Angami, learned counsel for the appellant. Also heard Mr. Fosiko, learned counsel for the respond number.
Sole respondent, Lordship.
So respond. Admit. List the matter for hearing.
Highly obliged.
May I please, your Lordship? My Lord, I beg to mention item number 15-23. My Lord, here I'm informed that the state has referred SLV in the apex court. So in the same subject, so Lordship may kindly allow 3 weeks time.
We'll have it listed before some other bench without me.
Oh,
So list this matter before any other bench, without one of us, within bracket, put my name.
much obliged.
May I please, your lordships? I beg to mention item number 10, hearing item number 10, lordships.
Yes.
I am appearing on behalf of NIA, Mr. N. Mishra, lordship.
Yes.
So I pray that let the matter come up after 4 weeks, lordship.
You want the bail to be cancelled. And you want adjournment.
Lordship, there was a shift of the PP lordship. And so the matter has been handed over to the new PP lordship.
On request made on behalf of Mr. N. Mishra and the counsel for the appellant. List the matter after 4 weeks.
4 weeks, lordships. Obliged, lordship.
May I please, Lordship.
Yes.
My Lord, in hearing item 11, both 11, 12 are mine. May I pray that item 11, I'm praying for adjournment of this 11. This is amicus curiae. I have been appointed as amicus curiae. I have not gone to the paper books, so allow me to give me a 1 week time after the 11.
On request made by Yezo, learned counsel, learned amicus curiae. List the matter. after-
Item 11. my Lord.
Yes.
Much.
Please, your lordships, I beg to mention item number 6.
6 will have to go for separate bench. Mr. TB Jamil.
Lordship.
Item 6.
Lordship.
Before any other bench.
Lordship.
List this case. Before any other bench, without one of us, within bracket, put my name.
Lordship, item 4 also, lordship.
Yeah.
Obliged, lordship.
Item 4 also. same.
Obliged. For motion, item number 1.
May it please, your lordship. My lord, the short fact of the case is, my lord, appellant who purchased a land from respondent number 3, who is a loanee, at rupees 59 lakhs. My lord, the respondent number 3 obtained a loan from the bank, that is from respondent number 2, that is Kannada Bank, in the year 2013. In the meantime, my lord, it has become non-performing assets. Then after that, the bank preferred an OA application before the learned tribunal. And the learned tribunal, my lord, passed a certificate amounting rupees 43 lakhs and odd. Now, DRT passed an ex parte order, my lord, keeping the charge of the certificated amount on the mortgage property, although there is no mortgage, my lord, in terms of section 58F of the Transfer of Property Act. Therefore, my lord, at the first place, that is the certificate issued. So far, the charge on mortgage property, it is without jurisdiction. And once, my lord, it is without jurisdiction, your lordship can take up the matter in under Article 226. My lord, second point is more, my lord, very crucial in the sense, my lord, they have manufactured, they have fabricated certain documents. Construing that, that is the equitable mortgage document. That is the order which has been regularized with the state government. And the state has come up with a, my lord, certain document which has been annexed in the read code, saying that these documents are all fabricated documents. Therefore, my lord, the decree obtained, whatever certificate obtained, is, my lord, playing fraud on the court. Therefore, on that count also, if a decree is ultimately obtained by fraud, my lord, that can be hesitated any point of time because it has become a nullity. So I will take your lordships to the evidence given by the bank officer, that is at page 126. The lordship will be surprised to see how the bank is, my lord, doing all these actions. The lordship may.
Why don't you take all these grounds before the appellate tribunal?
My lord, your lordship is very correct. That is
Why
the.
should you interfere?
My lord, if I take your lordships to all that thing, your lordship will be satisfied. Now, there are three contingencies when we can come before your lordship. My lord, I will take your lordship to that. It's a totally without jurisdiction. The tribunal, my lord, as your lordship knows, that at the threshold, they have to decide. At the threshold, they will have to decide whether they can make an inquiry. Now, have they decided that? The tribunal, knowing that there is no equitable mortgage, my lord, if your lordship look into the evidence, there is no equitable mortgage as such, they will have to file a original title deed before the court, before the bank. Now, that was not there and they have accepted even the evidence, if your lordship look at page 126. My lord, your lordship kindly see for a while. It's a case where, my lord, the requirement in interference at this stage is very much needed. My lord, your lordship look at page 128. What this gentleman is saying. I say that accordingly, the defendant as an absolute owner and possessor of land measuring so and so, village Dimapur, specifically described in the schedule below, created an equitable mortgage. Your lordship can see the language to secure the limit sanction and the money is advanced to be advanced to him and deposited his documents of title with the applicant bank as per loaning document executed on so and so. The following documents, your lordship kindly see what are the documents. Number one, order white dated 16/8/2013, original. They are construing this is the document of equitable mortgage. And the government has said this document has been fabricated and there is a the petition given, I mean, the letter given by the if your lordship, just for a while, look at page 206, last page.
Mr. Doctor, would you take us to the order passed by the DRT?
Yes,
There you
I'll take
are.
your lordship to that. My lord, that's a very vital thing, my lord. Your lordship may look at page 135. Page 135, I'll take your lordships to the relevant part at page 136. Second para, your lordship can listen. The defendant number one is absolute owner and possessor of land measuring so and so, so and so. An equitable mortgage to secure the limit sanction and so and so. Now, this is the averment. Then your lordship may kindly see at page 137. The defendant had neither appeared nor filed any written statement in the instant case, despite sending notices. Then the next para, your lordship kindly see, the applicant bank in support of its case has filed evidence on affidavit affirmed by Sri so and so, the manager, the following documents. Now, in these,
Who are you?
I am, my lord, the person who purchased that particular land from the loanee.
So you were not a party to the.
No, I
DRT
am not a
proceeding?
party.
Then why didn't you go to the DRT?
My lord, DRT, my lord.
See that did you out there? Did you have purchased out there?
Now, your lordship may see one thing. My lord, the recovery officer passed an order that said that they want to evict me from there.
But
Now-
if you go there before the DRT pointed out that you have this, whatever maybe I have my purchaser, I have purchased it. So
My lord,
there is no creation
yes,
of an
my lord.
equitable mortgage.
My lord, I totally respect your lordship's view. Now, here, my lord, if your lordship observe that before the recovery, because the recovery officer passed an order to that effect, your lordship may see that at page,
Recovery officer has gone in execution of the.
in
award.
execution, yes.
So
Now,
is it any jurisdictional error committed by the recovery officer?
my
No.
lord, my lord, it is in jurisdictional order. My lord, I will take your lordship to there.
How?
My lord, because he has no jurisdiction, because one thing your lordship can, is two part in the decree is there. Money decree, well, he has the power. But when you say you are giving charge on the mortgage property, whether there is a mortgage, one has to see that first.
So
My lord, your lordship,
Isn't it it's a question of determination of merits as to whether there was a creation of an equitable mortgage?
is not there at all. That is
That is a
why,
different thing. That is a question on merit, not on a jurisdictional error.
no, my lord, if your
And
lordship
that too
kindly
a
see.
jurisdictional error when there is an appellate forum.
My lord, jurisdiction error, my lord, I'll just take your lordship, one decision of the appeals court. The lordship has said, my lord, very emphatically it is said in, I'll paste that judgment. I'll read out that paragraph 57, my lord. From the aforesaid, it could be said in terms of a jurisdictional error that want of jurisdiction may arise from the nature of the subject matter, so that the inferior court or tribunal might not have the authority to enter on the inquiry. It may also arise from the absence of some essential preliminary or jurisdictional fact, where the jurisdiction of a body depends upon a preliminary finding of fact in a proceeding for a writ of certiorari. The court may determine whether or not that finding of fact is correct. The reason is that by wrongly deciding such a fact, the court or tribunal cannot give itself jurisdiction. Now here, my lord, what happened? The learned tribunal presumed that equitable mortgage has been created, although there was nothing. And it's an ex parte judgment, burden lies on him much to see that whether there is an equitable mortgage or not.
No, it was not an ex parte judgment.
Ex parte, my lord,
No, maybe it is an ex parte against them.
against them.
Why
I'm
didn't
not
you
saying about
approach?
me. My-
Why didn't
I
you
came in
approach
the recovery stage because they wanted to take my land by evicting me. And that too, my lord, forcefully.
And what is the name of the judgment? You are referring
That
to?
is, my lord. I can. give
No,
a
it's
copy.
okay. What is the name of the judgment?
That is, my lord, Central Council for Research in versus Bikartan Das.
That's the judgment of Justice Padiwala.
Justice, yes, Dhananjay Chandrachud and
I think authored by Justice Padiwala.
my lord.
Now, here is the case out here. If the jurisdiction is being conferred on a wrong assumption of fact,
Yes,
the court under 226 can look into it.
yes.
But here is not a question where a jurisdiction is conferred on a wrong assumption of fact. Here, it is on a wrong assumption of a fact, an order has been passed, not the conferment of the jurisdiction. There's a difference between that, Mr.
Lord,
Datta.
I accept that position, but then your lordship at the same time can see whether the presiding officer can say that this certificated amount will have a charge on the property. On what basis?
Let us assume absolutely he is wrong, but
No.
that's on merits, not on the jurisdiction.
My lord, even, my lord, this is one part of the thing. Second part is more very dangerous, my lord. These documents where they construe, my lord, I will take your lordship, kindly see that. My lord. Your lordship may see at page 91. Because in the evidence, my lord, the bank manager says, this is the document of equitable mortgage. And this is the fabricated document, my lord. Your lordship, kindly see the order dated 16th August 2013. A plot of land measuring so and so, then if you release, is hereby regularized in the name of Elomero. Now, these documents has been fabricated and putting before the court all these things, they have obtained an order. Can I not say that this order is obtained by playing fraud on the court? And if it is.
You purchase your land from whom?
From Elomero Luni.
So you purchase on the basis of this document only?
No, my lord,
Yes.
on the basis of his sale deed.
No, this is the document.
This is the document, but sale deed, my lord, and another thing your lordship kindly see. The sale deed, how it is made? Through notary public. Is it not hit by section 54 of the TP Act? Now, your lordship, why this sale deed is not before the tribunal? The reason is very obvious. Because can he say that this is a document of equitable mortgage? Now, my lord, your
It has been
lordship,
held to be fraud on the ground that at that relevant point of time, the deputy commissioner did not have the power to regularize. I think that is the reason
no,
why.
this is, they never issued this, my lord. It's a non-cadastral land.
But isn't it the person, are you not, have you, your right arises from Mr. Alomero?
That I have purchased from him.
Where is his right?
My lord, that's a question your lordship is putting, but then I am not in that, my lord,
So
in a
if
different
you are
angle.
saying that Mr. Elomero had purchased from somebody on the basis of a notarized thing, which is
Yes.
hit by section 54 or section 17 of the registration act,
17, yes.
then in that case, you don't have a title also.
My lord, that's a totally different chapter, my lord. Whether your lordship kindly see, whether the tribunal can pass on the basis of a document which is not there at all, it's fabricated one.
Why didn't you go and say it to the tribunal, look here, this is a fraudulent document, this is a question of merits.
My lord, your lordship is very, very right that way, but then, my lord, if your lordship observe that way, my lord, we can approach there. Your lordship kindly see the last page.
Yes, discourse.
My lord, your lordship will observe that my client can go before the tribunal and hesitate the matter. In the
Alright,
meantime,
you have appropriate remedies, you approach.
your lordship is sending me before the tribunal.
No, we give you the opportunity to do whatever you feel like. But the only thing is, this period during which your petition has been pending shall be excluded.
My lord, that's true, my lord, but then one thing, whether your lordship sending me before the detractory tribunal.
We are not. Here the single judge has already held it, that you have an appellate forum. That's your
Just
lookout.
because of that problem I have come, because your lordship kindly see, your lordship has the power under 226 when I can show that that three contingencies as your lordship is aware.
That is a difficult.
My lord, going there in a appellate tribunal, there are certain problem on behalf of my client.
You seek file review before that, the DRT. We need not say the provisions of the DRT Act is clear. You know how to do.
That's true, my lord. Your lordship's advices also help sometimes.
No. When the statute is already there.
You know, if your lordship kindly give an observation that way, it will be quite helpful.
Let's see.
Otherwise, my lord, going to Kolkata, apart from the financial problem, and there are so many things, my lord. For us, we can go, no problem, but for the client, it becomes a heavy taxation. That's the reason, my lord, because here is a case your lordship kindly see.
Mr. Datta, if you say more, we may have to deal with those submissions. The moment we deal with these submissions and negate it, you have more and more problems.
No, I believe your lordship is not going to do that. My lord, I leave to your lordships.
Yes.
Obliged, my lord.
For admission, item number 2.
Where's your affidavit?
May I please, Your Lordship, I may be allowed 2 weeks' time to file an additional affidavit.
That affidavit time has been given from,
Your Lordship,
for quite some time.
Your Lordship.
Now the rainy season has come.
Yes. Just one more fact to point out, Your Lordships. The extension for completion of the contract project was still the 31st of May. 31st of May has lapsed, and affidavit has been filed this morning, and the progress of the work is only 73%.
What happened to the SLP?
Still pending, Your Lordships.
Lordship, it's pending, it's coming off 30th of July. Lordship. It was last listed on February month, but due to the Honorable Justice was sitting with the Constitutional Bench.
Are you appealing? No, behind you.
No, my lords, I'm the legal manager on behalf of the charities.
You are the
Legal manager.
legal manager. How are you wearing a band? You go. Change and come back. Not inside the court. Yes.
Lordship, this matter listed before this Honorable Supreme Court in the SLP was on February. But due to the justice was sitting with this constitutional bench, this matter urgent to 30th of July. So Lordship, it is pending there. And the stay has been granted on the last round of this Honorable Court. And HDSL has given the UT till 30th of May.
See this. Yes, you were saying something.
Your Lordship, 31st of May, extension of time expired for completion of the contract project.
31st of May this year?
Yes, my lords. And so an affidavit has been filed this morning, and the actual physical progress is just 73%. Not yet complete.
Where's the affidavit? You filed the affidavit?
No, the contractor, my lords.
Who's the contractor?
Your Lordship, I'm sending on behalf of my senior judicial for respondent number 9 contractor. We have filed our affidavit this morning.
That,
Your Lordship.
that affidavit is defective.
Just this early hour, we have filed, Your Lordship.
Your affidavit is defective. So this is not going to file again.
Your Lordship, if some time may be given.
According to your affidavit, which you have filed,
Yes,
so
Your
it
Lordship.
is in the defective state.
Yes, Your Lordship.
What is the percentage of work that has been completed?
Your Lordship, the work progress has been completed for 73.07%, Your Lordship.
73.07%.
Yes, Your Lordship.
And the last date was 31st of May. Correct?
Yes, Your Lordship.
What's taking you so long?
Your Lordship, the work has been going on the last 24 till it was 65, but till yesterday it was 73.07%, Your Lordship. The work has been going on, but due to some technical issue.
We see no progress. At a point of time, cost was also involved.
Yes, yes.
50,000.
Yes, sir. It was, my lord.
Despite the imposing cost, you're delaying the matter.
Where is the counsel who was appearing for the NHIDCL? We've only asked him to remove his ban, not to disappear.
See, you are for the NHIDCL, isn't it? The affidavit has been filed by respondent number 9, saying that 73% has been completed. So according to you, okay. Where's Moaz Amir?
He is engaged in some other matters in district court zonal court, Your Lordship. As per our record, sir, Your Lordship, the total physical progress is 68.93.
68.9.
Your Lordship.
So counsel, respond number 9, you have, what you are saying is not correct. According to NHIDCL, it is only 68%.
Your Lordship, this 73.07% from yesterday, Your Lordship. Till yesterday, work done.
Should I tell you the reason why they are showing the 73%, Your Lordship? They have also taken the works which is incomplete, which is in the progress. We have only included the work which is completed. So that was the discrepancy in the.
What is the statement in the affidavit that 73% has been completed? Or
Yes, physical progress is 73.07%. Physical progress. So progress can be interpreted according to their convenience.
Yes. Where's your leading counsel?
Your Lordship is out of session due to some personal engagement. If Your Lordship may pass over a day, then Your Lordship.
Pass over?
A day, Your Lordship.
Heard Mr. Zimon. Let it amicus curiae. Stop. Mr. M. Timson, Leonard, edition AG. Nagaland. Appearing for the respondents 3 to 7, 11 and 12. Praise for another 2 weeks time to file an additional affidavit. However, we are not inclined to permit to allow 2 weeks time to the state respondents, and instead 1 week time is allowed to file the additional affidavit. Stop. On request made on behalf of Mr.
Joshua
Shikil and the counsel for the respond number 9. This is the matter again on 19th.
Much better.
For admission, item number 3.
May I please your lordships? In compliance with this Honorable High Court order dated 5/6/2024, the respondents number 2, 3, and 4 were directed to file the communication with regard to the pension scheme to the ministry. Accordingly, I filed my affidavit, lordship, and served a copy as well to the petitioners.
Yeah, please, my lord, I'm appearing on behalf of Mr. Gauhati, counsel for CGC Mano. So the counsel is yet to receive instructions. So kindly listen better after 2 weeks. Madam.
Yes.
Yes, Your Lordship, I've received the affidavit filed by respondent number 3, Your Lordship, yesterday, Your Lordship. Uh,
Now, after the affidavit is filed, does anything remain in the PIL?
Your Lordship, the respondent has not complied with the order dated 14/9/2022, Your Lordship. Your Lordship, they've done the verification only on the lease we have provided, Your Lordship.
14/9.
14/9/2022, Your Lordship, where this honorable court have directed to make a verification on the state, Your Lordship, within 3 months, Your Lordship.
Is it that 11/6/2024 affidavit?
11/6, Lordship,
Yeah,
Lordship,
you filed it on that day?
Lordship, Lordship. In my page 11, I have annexed a list of the eligible beneficiaries under old age pension for the entire state as well, Lordship. And page number 12 is with regard to the additional documents being filed by the petitioners.
You are presently giving these benefits to all who are there, page 11.
No, these are the identified additional, Lordship. On verification, these are the eligible beneficiaries yet to be given, Lordship.
Why you are not giving it?
Lordship,
Central
in my
government-
affidavit,
Kindly come to page 13 of your affidavit. Paragraph 2.
Lordship, the ministry is total ministry ceiling cap is only for 53,914, Lordship. So every year, as per the guideline, we do the verification, and this is the latest verification list beneficiaries. So we have already forwarded to the ministry for additional sanction, Lordship. Otherwise, then the entire scheme as a whole is implementing in total, Lordship.
It is a continuous effect.
Lordship, Lordship.
Every time it will change. because
Lordship,
every time
Lordship.
A new person will come
Lordship,
every year.
replacement due to death or whichever condition may be, So we accordingly do the verification and include the beneficiaries, eligible beneficiaries every year.
Yes, learned counsel.
Yes, Your Lordship.
As far as the petition prayer is concerned, Lordship, all the submissions are being heard, Lordship, accordingly and addressed. So at this juncture, I pray to this honorable court to dispose of the petition, Lordship.
Do you have anything to say?
Lordship, as per order 14/9/2022, Lordship, the state has made a submission before this court that they do the entire verification for the whole state, Lordship.
After that, the order of 21/2/2024 was passed.
Lordship.
They have already done it. If you see their.
Lordship, the direction given by this court on that day is that the verification report, compliance report be filed before this court in affidavit, Lordship. So in connection with that case, Lordship, we have assisted the state and placed before this honorable court the list of 198 beneficiaries. In that order, Lordship, this court has directed that if the list, 198 lists are found to be eligible, then maybe also be included, Lordship. So, Lordship, my petition, the prayers in my petition covers the entire state, Lordship. So, when the direction is given, Lordship, so far the state has filed affidavit, but that was concerned with only the list that we have provided. So they have not complied with this court's order dated 14/9/2022, wherein this court has specifically said that the verification report compliance report has to be filed in affidavit, Lordship. So if the state, they're saying that they've done it, then if the affidavit can be filed and the records may be placed before this honorable court, then the petition can be closed, Lordship.
See their affidavit, page 11. And it is always a continuous system by which every time there would be an increase every year.
Verification every year.
An old age person will come in, person may expire, whatever it may be. At page 11 of that, they say that at present, these are the list of persons who are there. Now, the ministry says that they would pay on the basis thereof. And the implementation has to be done. So the only thing is that we expect the state to implement it as per their.
Lordship, yes, then in that case, this petition can be closed with the direction, Lordship. Because what happens is, even I got a instruction from the petitioners regarding the particular village under Kohima village. Lordship, he was informed by the old persons, since he also helped identifying them, and then their names were given, and which these all people were aware. So they were anxious, seeing that some of our counterparts have received it through direct transfer benefit, whereas some has received through the village council in cash, Lordship. And where some have not received. So this kind of,
No, madam, what happens is, there are people who getting the benefit of 800, I think it's 800, no?
200, Lordship.
200.
200.
For getting the 200, they don't like to spend 1,000 opening a bank account.
Lordship.
That is why it is happening.
Lordship, and in fact, in my page number 11, the petition is confined only to old age pension, but the department has done the exercise with regard to Indira Gandhi National Widow Pension Scheme and Disability Pension Scheme also, which I've annexed in Annex 11, Lordship, the whole chart, Lordship. And it is not that all the old age people above 60 are getting. The guidelines is very clear to get the benefits only to PPL, Lordship. So it is not like if anybody reach 60 years and they get a pension, not like that. So the verification is been done comprehensively every year, Lordship, as per the guideline, Lordship.
Okay. Heard MS.
Nitya Kosa, Lordship.
Nitya Kosa, learned counsel for the petition. Also heard. You're appealing for?
Respondent number 8.
What is the PIL? Who are the respondents?
Lordship, I'm appearing for respondent number 2, 3, and 4.
For respondent number 8, my lord.
Who appears for what?
My lord,
MS B. Socrates, learned addition agent. Appears on behalf of respondent number 1. MS Apila Sankam. Learned counsel appears for the respond number
2, 3, and 4, Lordship.
2, 3, and 4. About RD,
respondent number 8, my lord.
respondent?
Number 8, newly implemented, my lord.
The
Yes,
CGC.
yes, my lord. My lord, I'm appearing as proxy counsel.
I see only 7. 7 is the Union of India.
Respondent number 8 has been implemented recently, my lord.
And Mr.
Elikasi Sangam, my lord.
Nikasi Sankam, learned counsel appearing on behalf of Mr. Gauhati, learned CGC for the respond number 8. So,
Madam, just
Lordship.
tell me, who is the sanctioning authority?
Rural Development, Ministry of Rural Development.
No, sanctioning authority. You see, every state shall designate a sanctioning authority at the appropriate level, municipality block level, as per page 35. Because if somebody does not get, we are closing the API.
Lordship,
We believe that the state will do it.
Lordship,
But where will they approach?
State only, Lordship, state.
Whom? You have, because kindly come to page 35 of the PI. If somebody is not getting the benefit, to whom
Yes.
should they approach?
Lordship, the department only, the Department
Which
of Social
department?
Welfare Department.
no. There is a sanctioning authority, specific.
Lordship.
Who is the sanctioning authority? Have you designated any sanctioning authority?
At appropriate level. Have you done that?
Lordship, that I'm not aware, Lordship.
Lordship, if I may request this honorable court that since Union of India is a very important party to the case and he's not appearing.
No, madam, that is okay. We have that letter of the Union of India.
Lordship.
Which is there enclosed. But only quarrel is if somebody is not getting the benefit, whom to approach. I think we need to get.
Lordship, that
Yes,
is,
your lordship,
Lordship,
yes.
Lordship, that is the district welfare officer, Lordship, in all the districts.
Have you appointed?
Lordship.
Where's the order?
Lordship, I have not annexed in the annexure, but
Because specific direction will have to be issued.
Lordship.
While closing this PIL.
Lordship.
So you'll have to file an affidavit saying that we have designated so and so person as the sanctioning authority.
Lordship, that is the district welfare officer, Lordship.
You bring it on record,
Lordship.
then we can very well direct that anybody who is aggrieved
Yes,
by
yes,
not
Lordship.
getting, they can approach.
Lordship.
Because we
What is-
believe that the state is doing, but if somebody is aggrieved, where will you go? You
Lordship.
can't come here
Lordship.
every time.
Lordship.
What document is this? This page 35 from page 25 onwards?
This is the scheme.
This is the scheme. The scheme. No, it is there. But then what is this? This is a continuation of this.
This is the scheme, guidelines, fact finding on all layer of the state of Nagaland.
Okay, cancel the order. Third MS Nito Koza, learning counsel for the petition. Stop. We have carried the affidavit dated 11/6/2024, filed by the respondents 2, 3, and 4. Wherein a communication dated is it 8 February, 8 June 2022, 2023, written by the Additional Secretary to the Government of Assam and addressed to the Secretary to the Government of Nagaland, no, not Assam, and addressed to the Secretary to the Government of India, Minister of Rural Development, Department of Rural Development, NSAB Division, has been annexed as Annexure 2, where stating that requesting for sanction of additional funds for 82 eligible beneficiaries under the IG NOAPS, in addition to the 17,137 beneficiaries proposed under NSAP. Stop. Sorry. We have also perused the old age pension scheme in the state of Nagaland, which is annexed as Annexure 3 to the present year. In the said scheme, it is provided that a sanctioning authority at the appropriate level has to be designated by the state government.
Nodal department,
By
Lordship.
the nodal department. Stop. Stop. Learned counsel, appearing for the respondents 2, 3, and 4, shall file an affidavit indicating as to whether the nodal officer has designated the sanctioning authority as provided under the old age pension scheme. Stop. Let such affidavit be filed on or before
1 week, Lordship.
on or before 18. Can you file it before
Lordship,
18? On or
Lordship,
before 18?
Lordship.
List the matter on 19.
Obliged, Lordships.
For admission, item number 5.
Please, Your Lordship, I'm appearing for 3 accused person. I filed my affidavit in opposition yesterday, but it was rejected since I failed to incorporate the phone number. As there's a new notification, it was not aware. So I may be
Okay,
allowed to
we'll
rectify.
list this matter tomorrow. List this matter on tomorrow's what date? 13th.
For hearing, item numbers 8 and 9.
This is a reference case. The issue involving the present revision petition is under Rule 31, whether the district incident judge can entertain an appeal against the decision passed by the village authority. When the decision passed by justice is to do, it passes judgment saying that the appeal is maintained. We will file the present revision petition by relying on the judgment passed by the justice. However, Lordship, while taking up this review petition, Justice E.B. Chaudhary be consented with the judgment passed by Justice Choudhury in the matter has been referred to the division bench.
Where is the order of Justice?
E.B. Chaudhary.
E.B. Chaudhary.
Lordship, in the record, Lordship. Judgment in order dated 8/4/2022.
8/4/2022.
Lordship, before coming to the order passed by Justice Arun Deep Chaudhary, Lordship, may kindly see the judgment passed by Justice Chaudhary. Since that order has been descended by this judgment passed by E.B.
Where's
Chaudhary.
the order?
I mean, Lordship may be allowed to produce the report.
Is it in this in the records?
No, Lordship.
It's not on record.
Judgment in order dated 8/6/2017, passed in civil revision 6 key of 2015. May I read, Lordship? This is a civil revision petition under Article 227 of the Constitution of India, directed against the judgment in order dated 23/4/2015 of the learned district judge Dimapur, passed in first appeal number 23 of 2013. When the learned district judge returned the first appeal filed by the petitioner against the order of the Burana Bazar Village Council, East Dimapur, dated 30/11/2013, in reference case number so and so, on the ground that the Court of District Judge has no jurisdiction to entertain the same, in view of the judgment and order dated 16/9/2013 of this High Court passed in case of Registrar General, Gauhati High Court versus Union of India, and others reported in 2000 so and so. Right, Mr. Lucam, learned counsel for the petitioner, as well as Mr. So and so, learned counsel appearing for the sole respondent. The case of the petitioner, as submitted by Mr. So and so, is that the petitioner was married to the respondent and lived together with her for more than 16 years. But on mutual agreement, he got divorced on so and so. And thereafter, the petitioner got married again with another woman, while the respondent remained unmarried. But on compassionate ground, the petitioner allowed the respondent to live in one of his houses situated at Burana Bazar in Dimapur without charging her rent, and also give her monthly allowance of rupees 20 for maintenance. Besides, the respondent was also allowed to collect and enjoy house rents amounting to rupees 20. However, the respondent, with the intention to turn the house, she have been allowed to go by into her own property approached the Sumi Council, East Dimapur on so and so. The council, after hearing both the parties, passed a judgment in order dated so and so, whereby the residential premises, which was under the occupation of the respondent, was divided into two portions between them. Agreed by the said judgment in order, the petitioner approached the learned additional district in Sin Judge Dimapur by filing first appeal number so and so. The same was contested by the respondent, however, by judgment in order dated so and so. The judgment passed by the Sumi Council, East Dimapur, was set aside. And the respondent approached the village council of Purna Bazar, claiming as she did in the first case. The petitioner once again contested the claim, but the village council of Purna Bazar, by ex-party judgment in order this divided the residential premises of the petitioner into two portions between them, as done in the earlier judgment of the Sumi Council. Aggrieved by the same judgment in order, the petitioner approached the district judge of Dimapur by filing first appeal number so and so. Under Rule 31 of the Rules for Administration of Justice in Police in Nagaland, Third Amendment, X so and so, read with Section 96 of Order 41 of Rule 1 of CBC 1908. The learned district is in Judge Dimapur, however, returned the appeal on so and so, stating that the district court has no jurisdiction to entertain the appeal in view of decision of the division bench of this High Court and WBC number so and so in case of Registrar General Gauhati High Court versus Union of India in others as reported in so and so. Mr. So and so, learned counsel for the petitioner, submitted that the district judge was erroneous in deciding as such, because the jurisdiction of a bill as conferred under Rule 31 of the Rules for Administration of Justice in Police in Nagaland, Third Amendment Act so and so, in the provision of Section 96 in Order 41 of Rule 1 of CBC of 1908 were not removed by the state judgment in order of this High Court. The learned counsel referred to Rule 31 of the Rules for Administration of Justice in Police in Nagaland, Third Amendment Act 1984, and submitted that the village council is included in the expression in other duly recognized village authority mentioned in the same rule. Therefore, decision of village authorities, which was available before the deputy commissioner, is available before district judge, to which the power of the deputy commissioner relating to civil dispute has been passed over after separation of judiciary from executive in Dimapur district. Para 5, Mr. So-and-so, learned counsel for the sole respondent, submitted that he has no different opinion from what has been stated by the learned counsel for the petitioner on the provision of law relating to the appellate jurisdiction of the Court of District Judge. Elaborating learned counsel submitted that thou Section 14 of the Nagaland Village Council Act 1978, by which judicial power was given to village council, has been deleted by the Nagaland Village and Area Council Amendment Act 1985. But because of the provision of Rule 24 of the Rules for Administration of Justice and Police in Nagaland Amendment Act, the village council are still empowered to exercise judicial powers. And decisions of village councils are available before the deputy commissioner under Section 31 of the Rules for Administration of Justice and Police in Nagaland, Third Amendment Act 1984. However, in the district of Dimapur, since judiciary has been fully separated, the power of deputy commissioner in matter of adjudication of civil disputes has been given to the Court of District Judge. Therefore, Court of District Judge Dimapur has the jurisdiction to entertain the appeal and to decide the same on merit. The learned counsel cited the judgment and order of this court dated 16/9/2013, passed in the case of Registrar General Gauhati High Court versus the Union of India and others, and WBC number so and so reported in 2000. Particularly, para 32 and 33 of the same, and submitted that the judgment did not in any way say that the Court of District Judge has no appellate jurisdiction over the judgment and order of village councils. Para 6, the relevant rules and decision referred to by the learned councils are reproduced here below for easy reference. Rule 24 of Rules for Administration of Justice and Police in Nagaland, Third Amendment Act 1984. Mazadars, Kampuras, chief, admins of kills, Dobashis, or other village authorities sitting in the village elders with the village elders and councils are empowered to try cases without limit as to amount, but with the following reservation. Clause E, he may not try suit in which a native of the land or native of another village not resident in their jurisdiction is a party. clause B, all suits be decided in open tabard in the presence of the parties in at least 3 respectable witnesses. Rule 31 of the Rules for Administration of Justice in Police in Nagaland, Third Amendment Act 1984. An appeal shall lie from the decision of the Mausather, Kampura, Chief Headman of Kil, Dobashi, or other duly recognized village authority to the tribal courts whenever constituted or otherwise, to the Deputy Commissioner or his assistant. A record shall be made of the matter in dispute in the decision of the village authority. If necessary, the court shall examine the parties, and if the decision appears to be just, shall affirm and enforce it as one of its own. If the court sees reason to doubt the decision of justice of the decision, it will.
Mr. Counsel.
Yes, Lordship.
How would the district judge exercise that power? The portion you are reading. That portion. Otherwise, de novo is okay. The second part is okay. Or if he doubts the decision, he may go for a de novo. This is okay. Then that will be filing of claim and all these things. This will happen. But how will the district judge exercise this portion? Under what provision? That's the problem.
I'm allowed to conclude this one, this part. I'm allowed to conclude. If the court sees reason to doubt the justice of the decision, it will try the cases de novo or refer it to a panchayat as above. Minutes of the meeting held in the residence of Honorable the Chief Justice, Gauhati High Court on so and so at so and so. Present so and so so and so. That I'm not referring. Lordship might be allowed to read only the decision, the resolution which has been adopted in the meeting. Lordship, just below the name of the representative. The issue of separation of judiciary from executive in the state of Nagaland was discussed by the Honorable Chief Minister Nagaland and Honorable the Chief Justice, Gauhati High Court, in the presence of Honorable Mr. So-and-so, 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 so-and-so. Lordship, I'm not repeating the name. Lordship, I'm allowed to come to the again next part. In the meeting, it has been decided that the state government shall notify the Nagaland Judicial Service Rule 2006 in terms of the apex court directives. Lordship, the rule has been already framed. Since more than 90% of population in the state is tribal, it has been imperative to educate the people of the fact that the protection given to customary laws in terms Article 371E of the Constitution shall continue to be enforced. For the opposite reason, it has been decided by the government to effect the separation of judiciary from executive in a phased manner. Accordingly, it has been decided to effect the separation of judiciary from the executive in Dimapur in commercial capitals of the state. It has been further decided that the aforesaid separation shall be effected in the remaining district in a phased manner within reasonable period. Para 3, it has been decided in terms of the approval of the state government that the Nagaland Judicial Service Rule 2006 will be implemented in Dimapur and thereafter in the other district in phased manner. We come to Para 7. From the contents of the Rule 24 and 31 of Rules for Administration of Justice in Police in Nagaland, Third Amendment Act 1984, given above, there is no doubt that Village Council too shall enjoy certain powers to adjudicate civil disputes, particularly in matters relating to customary laws. And their decisions are appealable before the Deputy Commissioner or his assistant. Further, reading together of the minutes of the meeting held at the residence of the Honorable Chief Justice of this High Court in the notification issued by the Department of Law and Justice, Nagaland, it appears that decision for total separation of judiciary from executive in phased manner has been taken and implementation of the same has been started with the District of Dimapur. In view of this change that has taken place, the power of Deputy Commissioner under Rule 31 of Rules for Administration of Justice in Police in Nagaland 1937 has to be understood as transferred to the district judge, especially in respect of the District of Dimapur. This was the finding the conclusion arrived by the Justice is circulation. Therefore, the learned District Judge Dimapur should have admitted the appeal and decide the same on merit. The judgment of this High Court rendered in the guise of Registrar General Gauhati High Court versus Union of India and others, and WBC is so and so, reported in so and so, does not in any way block the jurisdiction of the Court of District Judge Dimapur in adjudicating such cases. In view of what has been stated above, the impugned judgment in order of the learned district in judge so and so, passed in so and so, is quashed in set aside. According, the district judge Dimapur shall admit the appeal and dispose the same on merit. Lordship, we filed a present revision petition by relying on this judgment. When the matter was taken up, Lordship, the Justice, Honorable Justice E.B. Chaudhary has dissented with the judgment passed by Justice Sir, and now the matter has been referred before the division bench. Lordship, I will be allowed to read the judgment passed by Justice E.B. Chaudhary, Lordship.
Before you do that, you answer the question raised by my brother. How will the district judge exercise that first portion? Secondly, you see the 1887 Act, which applies to the state of Nagaland. It is based upon a power under Section 9, a civil court, or by any statute, any power is being granted. Just for example, the district judge could have been granted the power under the Trademarks Act, the Arbitration Act. But if the administration of rules of justice does not provide that power, how will the district judge do it unless there is an amendment?
Lordship, that is a findings come by Justice E.D. Chaudhary also in his judgment.
Understood. That is one. And how does Rule 31, the first part, is being done? It may be a different thing. The district judge, the DC may say tomorrow that, okay, while de novo, we refer it to the, that is also another aspect of the matter, whether we can do it or not. That is another aspect. But how an appeal, if the statute does not prescribe a particular thing, an appeal, because the jurisdiction of the district judge is in terms of the 1887 Act. And that is, as per the full court judgment, the 1887 Act applies. If 1887 Act applies, there is no first the jurisdiction to the district judge. Some jurisdiction has to be conferred. It is a civil court. And the civil court has not been granted the jurisdiction in terms of the 37 rules. How do you take care of that?
Lordship, in the revision petition, Lordship, one of the ground which we have taken is, Lordship, we have relied on the notification dated 22nd May 2008, passed by the Department of Justice. By this notification, only the nomenclature of the Deputy Commissioner Judicial. Now the Deputy Commissioner Judicial. Now their nomenclature has been changed to District Judge. By this notification. But not the power.
No, and not only that. By this notification, you need to amend that. The rules.
In that case, now we are left with nowhere to go for an appeal against a decision passed by the village authority. Unless the state government take the decision to amend the 1947 laws. If you can, kindly see in my revision petition, page number 60. This is the notification. Here the power has not been transferred. Only the nomenclature has been changed. So after the state government issued this notification, you should have taken a step to amend the 1937 rules. So far that has not been done by the state government. So because of the action of the state respondent, was stumbled. That is the issue. Can you see page number 60? Recently, the state government, they've constituted a committee to look into the matter for framing the Nagaland Civil Court. Lord, the committee, they have already drafted the rules. Now the matter is placed before the state government. Respect remaining my learners in your role.
May it please your lordships. In the first place, if the rule is deleted in terms of the Registrar General's case, we have no problem. Even if a separate customary court is being constituted for trial of customary matters, we have no problem. The only problem now is that because of the Registrar General's decision, now we are in a dogma. We have nowhere to go. And although we are not now challenging the case of the decision of the Registrar General's case, in order to better understand the facts existing in Nagaland, I would like to go back to the decision itself and also the decision made for reference. In the case of Registrar General, the submission of the amicus curiae, I would like to read it out. That is at paragraph 19.
Paragraph 19 of?
Paragraph 19 of the Registrar General of Gauhati High Court's case. No, that doesn't matter. Enclosure 3 in that compilation of decisions, and there's a 3. Paragraph 19. This is the submission of the amicus curiae, which has been accepted by the learned division bench. May I read the lordship? Paragraph 19. May I read the lordship? Learned amicus submitted the exclusion of CRPC from the state of Nagaland and other tribal areas under proviso to section 1, 2, and of CPC under proviso to section 1, 3 thereof is only applicable to village councils / courts or the customary courts or authorities exercising judicial powers under the administration of justice rules and not regular courts manned by members of Nagaland Judicial Service taken to have been constituted under the Civil Courts Act. The 2009 Act expressly clarified what is otherwise implicit. He submitted that the above provisos have to be given purposive interpretation and not literal interpretation to avoid absurdity. Since two interpretations are possible, one to read the proviso as applicable only to customary courts or courts presided over by executive officers under the administration of justice rules, as well as to regular courts manned by judicial officers, and the other as applicable only to customary courts and courts presided by executive officers. Interpretation which promotes the intention of the legislature and policy of law has to be preferred. The purpose of the proviso has to be ascertained in the historical background of the laws applicable to the state of Nagaland and other tribal areas. In the state of Nagaland versus so, the history of administration of justice in the state of Nagaland has been notified. It was observed that the courts set up under the administration of justice rules were manned by executive officers, and such courts constituted a separate class, not being at par with regular courts. Therefore, there was no violation of Articles 14 and 21 in CRPC, not being applicable to the courts manned by executive officers. The legal position has undergone sea change after the said judgment. Separation of judiciary, which is a directive principle under Article 50 of the Constitution, has acquired the force of a mandate after the decision of so-and-so, as held by the full bench of this court in Dobashi Chakraborty's. Accordingly, judicial services have been created and regular courts have been set up. It will be absurd to attribute intention of excluding CRPC and CPC from proceeding before regular courts in these circumstances. By such interpretation, the purpose of law will be defeated and administrations of justice and regular courts will be hampered. There will be no uniformity in the procedure followed in regular courts in the state of Nagaland and other states without there being any difference in the circumstances or functioning of these courts and other courts. Purpose of law will thus be advanced if the bar is taken to operate only to customary or village courts or other regular courts. Now, in the first line of this paragraph, the application of CPC and CRPC, according to the amicus curiae, is confined to the customary courts or village courts. That is not correct. That is not correct.
In view of Rule 26.
Your Worship, that is not correct. Then, on the basis of these submissions, now the division bench come to its conclusion. At 5:32. It is thus clear that if legislative intent is to bar applicability of CPC and CRPC to customary courts or courts manned by executive officers, the said bar cannot be held to be applicable to regular courts. This interpretation will be harmonious with the functioning of regular courts under the Civil Courts Act and also customary or executive courts under the administration of justice rules. Accordingly, we hold that the Bengal, Agra, and Assam Civil Courts Act 1887 is applicable to the district of Dima Hasao and Karbi Anglong in the state of Assam and the state of Arunachal Pradesh and Nagaland. The administration of justice rules applicable to the state of Nagaland and the Northeast Frontier Administration of Justice Regulations 1945 applicable in the state of Arunachal Pradesh will give way to the provisions of the Civil Courts Act to the extent of inconsistency in relation to functioning of courts manned by members of the cadre of judicial service. Now, next paragraph 33. We further hold that CPC and CRPC are applicable to the regularly constituted civil and criminal courts without in any manner affecting operations of 371A or the functioning of village, customary, or any other courts other than the regularly constituted civil and criminal courts in the state of Nagaland manned by the members of judicial service. Therefore, an impression has been given that there is a customary courts in Nagaland and that the application of CPC is CPC is only confined to those village or customary courts. That was the impression given by the amicus curiae. And accordingly, the decision has come up. Now, let me take your lordship to the rules.
Mr. Iranu, what do you say on this last line in paragraph number 32?
32.
Yes, of the judgment. The administration of justice rules applicable to the state of Nagaland and the Northeast Frontier so and so applicable in the state of Orissa will give way to the provisions of the Civil Courts Act.
Yes.
To the extent of inconsistency in relation to functioning of the courts manned by members of the cadre of judicial service.
Your lordship, in my view, now if this is applied, then the rule is gone. And let the rule go. We do not mind. But when the rule goes, now what will happen to the existing proceedings which have been filed before the village courts or village councils or gamburas or DBs? Where do the aggrieved party goes in appeal?
And on that is one thing. The second, kindly see paragraph 33.
Yes.
That division bench further retains.
Yes.
The powers of the village courts. We further there says are applicable to the regularly constituted so and so without in any manner affecting the operation or functioning of the village and country.
Yes.
Now, if those rules go,
yes,
where will there be a village or customary?
Now, the other question is whether there is a village customary courts, any customary courts in Nagaland or not. That is the question. And whether the village courts or Gambara or Dobashis, whether they are designated as customary courts under the rules. It is no. There is no such court designated as customary courts in Nagaland. And for that purpose, I would like to take lordships to the rules. Rules. The first rules, the 1937 rules, in this blue book by Justice Richard Z. Angamir at page 75. Page 75. I would like to start from the general one, general. May I proceed, lordship? The administration of district known as the Naga Hills is vested in such tribal authorities as may be constituted according to rules to be made by the Governor of Assam, by the Governor of Assam, the Deputy Commissioner, the Deputy Commissioner, and assistants to the Deputy Commissioners, the Mazadars, Ganburas, Chiefs, Headmen of Khels, and such other classes of officers as the Governor of Assam may see fit from time to time to appoint in their behalf, subject to the exceptions, restrictions, and rules hereinafter recorded. Now, this is the 1937 rules. Now, coming to page 85, Rule 23, which deals with civil rule. Page 85, Rule 23. The administration of civil justice in the Naga Hills is entrusted to the Deputy Commissioner, his assistants, within bracket, such tribal courts as may be constituted according to rules to be made by the Governor of Assam, and the Mazadars, Gamburas, chiefs, headmen of Khels, and other chiefs, village authorities. 24. Mazadars, Ganburas, chiefs, headmen of Khels, or other village authorities sitting with the village elders in council are empowered to try cases without limit as to amount, but with the following reservations. A, they may not try suits in which a native of the plains or native of another village not resident in their jurisdiction is a party. B, all suits to be decided in open dabar. Now A, this means the Ganburas, chiefs, headmen of Khels can try any case, whether it is customary or civil, purely civil in nature, and these are not customary courts. The rule did not say that. Because if the native of the plains is not resident within that village, he cannot take up the case. But if a native of the plains is a resident of that village, means a non-local, a non-Naga, then the court can take up the case, which means that the no customary laws has nothing to do with this. So these are Gamburas, chief headmen, these are not designated as customary courts. But in view of the submissions made by the amicus curiae, now, and as well as the decision for reference made by the learned justice, they are all under the impression that there exists in Nagaland a separate customary court constituted under the rules as provided in order to protect the customary laws as given under 371A. That was the impression.
They must have read it, Rule 23 as it is, as presently seen.
Yes. Now, and also, now when this decision was made, now submission was made that DC includes DC Judicial, ADC Judicial. Now, the decision bench of, in this case, goes on the pure surmise, on the pure premise that only the DC executive, ADC executive has to exercise powers under the rules, but not ADC Judicial and DC Judicials. That was the impression. And under the premise that there exists a customary courts in Nagaland, both these two courts have given that decision. Now, if there is no customary courts, then chiefs or headmen of Khels or Gamburas they can try any civil suits. And your lordship will see why
And what is the present rule, Mr. Irani? What do you say about page 27 of the?
your
book?
lordship, let me, in this, rule 35 also is relevant. Rule 35, page 87. The High Court and the courts of Deputy Commissioner and his assistants shall be guided by the spirit, but not be bound by the letter of the Code of Civil Procedure. Now, according to amicus curiae, this application of CPC is only to the village courts or the customary courts, which is not correct. And although we are not under the, we are not challenging now this Registrar General's decision. Your lordship, there are certain things which are what to say? Because now under the CPC, the application of CPC, the authority is with the state. But while the court says that the CPC is applicable in Nagaland, a direction also or an advice was also given that the state may issue a notification for the application of CPC. I believe that is not the correct way. And then, till today, the rules, the central acts and rules, Assam regulations and other central regulations which are applicable in Nagaland prior to 1962 and still applies, and whatever is provided there is applicable in Nagaland, in which Civil Courts Acts was excluded. Transfer Property Act is excluded. Contract Act is included. Many acts are included, but those two acts, because Transfer Property Act, it deals with properties, inheritance, etc. So that was not made applicable, perhaps because of 371A. Then CCA Act is nowhere mentioned under the rules in volume 1. But that also has been made applicable. In fact, if it is to be made applicable, it has to be made by the state government, by a resolution of the assembly, that this act is applicable, this regulation is applicable of Assam or of the Central Act. Therefore, we are facing the confusion. Let the rule go, but pave a way how the present litigants has to approach the courts in appeals or revisions in the absence of customary courts. Because Chapter 4A now by amendment, subsequent amendment of 1984.
And before that, just come to page 27 of that book.
Oh, yes, 27.
This is the rule 23, which we were showing later on.
Yes. Now, this is subsequent amendment, 1984. Now this, in 23, rule 23, chapter 4A has been included.
And they mention about customary court.
Yes.
And
The constitution of customary courts.
And constitution is in 4A.
Yes.
4A would be page,
4A would be
rule
page
39, page 51.
Yes. Now this is not enforced. That is the problem. Even the reference code refer to this one as if this is applied. But this is not enforced. That is our problem. Now, your lordship,
But rule 23 at page 27.
Yes.
Is it enforced?
Rule 23 is enforced.
This is enforced, but
But-
23 says about chapter 4A, chapter 4 is not enforced.
Not enforced. Now, your lordship. In this book, late Justice Zero has meticulously prepared all these things. Whether these are enforced or not, by which notification that has not been enforced, he has given everything. And page 95.
So without chapter 4 being there,
Yes.
how do you enforce rule 23? Because rule
Because-
23 basis is chapter 4A.
No, no, your lordship. This civil justice is entrusted to deputy commissioner, additional deputy commissioner, assistant deputy commissioner. But deputy commissioner includes deputy commissioner judicial, and additional deputy commissioner includes additional deputy commissioner judicial.
It's okay.
By definition.
Then customary courts constituted under chapter 4A.
Yes,
Now, chapter 4A being not brought in,
yes.
where is the customary court?
There is no customary courts.
So therefore, rule 23 as it stands,
Yes,
so far as customary courts, therefore the Registrar General, as 23 has been brought in the year 1987
yes.
or 1989, the Registrar General judgment came up and said that yes, there is a customary court.
Yes, that was the impression.
Yes, but a customary court has to be on the basis of the constitution in terms of its rule, chapter 4A.
Your lordship,
And chapter 4A has not been brought in.
true,
So there is no customary court.
there is no customary courts. But everybody is under the impression that the village courts, Gamburas, Dobashis, they are customary courts. Whereas in reality, it is not. No statute has designated them as a customary courts. Therefore, despite the change of the nomenclature from ADC judicial, DC judicial to district extension judge, additional district extension judge, it does not oust their original jurisdiction. Even after their change of the nomenclature in 2006, they exercise their powers under the rules. They continue to exercise their powers under the rules. And therefore,
Because that notification is just a nomenclature.
yes, it does not oust its functions and powers.
The 22.
Yes. And therefore, since Gamburas from the lowest level, they can try any civil suits, any case. Now appeal comes up under Rule 31, then 29.
What is rule 24 then? At page 28, has this been notified?
Rule 24.
Is this notified?
This is same as the first one, the original.
Understood, but is this notified?
Yes, this is enforced.
Now, if it is notified, now the Dobashi courts get the jurisdiction, but a limited one.
Yes, they can, Dobashis can try those cases which has been only referred to them by DC or ADC or assistant to DC.
Now, this is 23A.
Yes.
This is notified.
Yes. By subsequent amendment, this was.
This is
added.
notified.
Yes.
Now 24.
Yes.
Finally, see, Mozada, Gaunbura, Chief, Khel, so and other village authorities sitting with the village elders in council are empowered to try cases without limit to any amount, but with the following reservations. They
Yes.
may not try suits in which a native of a plains or so not resident in their jurisdiction is a party. All suits be decided in open darbar in so and so. So
Yes.
this, so here there is a jurisdiction being given
Yes.
to the Muzadas, Gaunpura chiefs, headmen of Khels.
Yes.
And simultaneously, in this particular provision, it says about the Dobashi also.
Yes. Yes.
So here, Dobashi court can exercise this jurisdiction.
They have, but in order to exercise their jurisdiction, the matter has to be referred to them by DC, ADC or assistant to DC.
So in view of 23A.
Yes. Otherwise they cannot.
But the Muzada Gaunpura chief or headman can very well decide on their own.
Your Lordship.
But the Dobashi cannot.
Your Lordship.
Now, there are other judgments to the effect that against the orders of the Muzada Gaunpura chief health or village authority,
Yes.
the Dobashi cannot sit.
No.
Now, where is the village authority? Village council concept in these rules?
Village, Your Lordship, village council, it was not included here, except it may come under the other village authorities. But under Nagaland Village Council Act, at one point of time, village council was given the jurisdiction to try cases where there are two villages in dispute. Subsequently, that was deleted. But again, by a subsequent amendment, again, that was restored. And the other thing is, Your Lordship, in 2022, I understand, a very funny thing also, Your Lordship, how things are going on in Nagaland, Your Lordship. We need to streamline, otherwise litigants are suffering. Now, in 2022, the government has published a notification in the Gazette declaring the village council as village court. And from the decision of those village court, appeal lies to district subordinate customary court. Now, this district subordinate customary court has not been constituted. Where the party will go in appeal?
And this is under what provision?
Your Lordship?
Under what provision? Means this insertion is being made, amendment is caused to which act? This
Your
act-
Lordship, Annexure 10.
Huh?
Annexure 10 will see the notification published by the government. Enclosure 10.
Enclosure in your.
Yes.
Oh, this is to the Nagaland Village and Tribal Council Act.
Yes. You that relevant portion. Relevant portion is amendment of section 14(5), rule 5. Administration of justice.
What is it? Section?
5, rule 5. Section 14 of the Principal Act with the title Administration of Justice, deleted by Nagaland Village and Area Councils Amendment Act 1985, the Nagaland Act number 6 of 1987 shall be reinserted as under. The village council shall function as village court as envisaged under rules for administration of justice and police in Nagaland 1937 as amended, and administer justice within the village limits in accordance with the customary law and usages and accepted by the canons of justice established in Nagaland and the law in this respect as enforced from time to time. Further, any appeal against a decision of the village court shall lie with the subordinate district customary court and district customary courts as decided by the area administrative officer or the deputy commissioner. Now, these two courts, district customary court and district subordinate Customary court has not been constituted. Because that will come under chapter 4A of the rules.
But where is the village court?
Your Lordship?
Chapter 4A
Yes.
says about village court.
Village court, customary courts, yes.
But 4A has not been brought
4A
in.
is not there.
So without 4A, can this clause have any
No,
impact?
it cannot. And therefore, now if somebody files a case in the village court and the village court tried the case. Now next is if aggrieved, where does the aggrieved party go? Because there is no subordinate district customary court. Because from village court, next appeal is subordinate district customary court. And under chapter 4A, this subordinate district customary court has no appellate jurisdiction except district customary court.
But if we see again, chapter 4A at page 39 or something, page 51. That is rule 39.
Page
51.
51. Yes.
Here, the customary court is a village court.
Yes.
So this village court, then you have the subordinate district customary court.
Yes.
Then the district customary court.
Yes.
So these are all these courts.
Yes.
So this village court is the same village court out here, or is it a separate village court formed?
I don't know.
Because
I
here
don't
they
know.
may- because why I'm saying the village council shall function as a village court
Yes.
as envisaged under so and so.
Yes.
That means the village council under that village council act
Yes.
shall be a village court
Village court.
in terms with this. But this, there is no village court here.
But when this 4A is not enforced,
Yes.
how they can refer to this one? You. Yes. Yeah. Now, Your Lordship, I would like to make another submission. Under the definitions as given under the rules, general rules for the administration of justice. Now, page 1, deputy commissioner includes additional deputy commissioner judicial and additional deputy commissioner judicial. So deputy commissioner includes deputy commissioner judicial and ADC judicial. ADC judicial. Now in 2008, this nomenclature was changed to discretion judge. So by implication, this rule has been changed. So appeal lies to the deputy commissioner judicial, district instruction judge, additional district instruction judge, or CGM as assistant to senior judge division or junior judge division.
Let us see that amendment where you can.
The trade.
No, but one thing,
Yes.
if you see that notification of 22nd of May 2008, this is a power exercise under 309.
Yes. Yes.
Not an amendment to these rules.
No, not by amendment. True.
So can by changing the nomenclature under 309, which is the service.
But even after change of these nomenclatures, district assistant judge, additional district assistant judge, chief judicial magistrate, both and civil judge, junior, senior, they exercise their powers under the rules.
Understood. But
Under
that
the
is under
rules.
309. Article 309.
Yes, but practically they exercise their powers, they exercise their powers derived from the rules. Since 2008 also.
No, no. This can be done the moment are these people, those DC judicial, by implication of 309, if it is done, would they come within the fold of those judicial service of the state? Nagaland Judicial Service?
Yes, they'll be appointed with the approval of the High Court.
So they will become the judicial service.
Yes, they become judicial
But
service.
for the purpose of the rules, there is no amendment.
But they continue to exercise their powers from the rules.
Understood, but for the purpose of the act, there is no, the rules, there is no amendment. How do you?
There is no
incorporate-
amendment. This is why this problem has come up. And this is why the Registrar General case has come up in this manner. How do you go about it? The Lordship has to find out a way. Now, in the case of not Arunachal, but in the case of another, the rules, even in the case, the rules were deleted by implication. And
Arunachal has come up with the civil court rules.
yes. And I'm not sure whether that has been reflected in this Registrar General's case, but in another case, the rules was deleted, and all the pending civil cases were transferred to civil courts under the Civil Courts Act.
That's the Arunachal.
That should have been done even in the
Yes.
present case. If that is done, then no problem.
In fact, the Arunachal rules has a similar parameter provision.
Yes.
The Civil Courts Act
Yes,
has a parameter provision to 31.
yes, yes.
Wherein it says that if the appeal can lie from a year and the provision has been given, the district, the
Yes.
appeal lies to the district judge.
Yes,
And the district judge may either affirm it on the basis of whatever it is,
Yes.
without going much into, or may have a demo.
yes. So far, the executive side is concerned, in Nagaland, it is same. The difference, the learned court have not been apprised of, that we have DC judicials, ADC judicials in Nagaland. Whereas in Arunachal, it is not there. It was not there then. But in Nagaland, we have. And these judicial officers are trained, legally trained officers. All graduates, law graduates.
Here, you see what they say in the Arunachal jurisdiction, appeals. Rule section 15 of the Arunachal Act.
Yes.
Appeals from a decree or order passed by a court of the district judge and a court of air lies to the High Court. Appeals from the decrees or orders passed by a court of civil judge, senior division in original suits, and proceedings of civil nature shall, when such appeals are allowed to lie to the court of the district judge of the district or to the court of the additional districts where the court exists, to the High Court as the case may be. Then you see an appeal from a decree of the civil court or so and so in the original or civil nature, wherein it shall lie to the civil judge senior, provided that any appeal or suit pending in the court of the deputy commissioner shall be disposed of to the, now you see the disposed of by the concerned deputy commissioner under the provisions of the Assam Frontier Administration Rule as expeditiously as possible,
Yes.
but not later than 1 year from the date of coming into force of the Act.
Yes.
Provided for further that from the date of commencement, in case an appeal prepared before the court, judgment of a customary court in the court of the district judge or court to the so and so as the case may be, the court of the district judge or the court of the district may dispose of the same or proceed with the case de novo. So it gives a similar power.
Yes.
May either proceed with the same.
Yes.
Or de novo.
Yes.
So it is similar to 31.
Yes.
So that is what it is being given.
Yes.
Yeah. So
No, Your Lordship, I'll bring another confusion to Your Lordship. Do that. Enclosure 5, Your Lordship may kindly see. Enclosure 4. First, let us see enclosure 4, Your Lordship. This is a notification dated 20th December 2013. The government of Nagaland hereby notifies that the provisions for the rules for the administration of justice in Nagaland, which empowers the deputy commissioner and the assistant under Rule 15, this is dealing with criminal 15, are still in force. Therefore, the powers invested by the rules are to be exercised concurrently by the deputy commissioner and his assistants, except in Dimapur, Moza, where separation of judiciary from the executive has been affected. Now, when this notification was issued, the matter was taken up by the court. That page next, enclosure 5. The relevant price, sub-price 1, 2, 3, 4. The said notification, starting from the said notification, referring to this notification dated 2012-2013. The said notification prima facie appears to be in violation of the decision of this court in the OPC number 5783/2006 and other batch of cases. In that view, registry to register a case and notice to be directed to be issued to the government, advocate, Nagaland, and the case be posted in the next week. So prima facie, this notification in violation of that Registrar General's decision. And then subsequently, in Procedure 6, this notification was, what they say, recalled, withdrawn.
no, the reason must have been for that notification is that initially it will be only applicable in Dimapur. In others, we will do it phase-wise. So they will, therefore, to clarify. they must-
Except in Dimapur.
That is why I say
Yes.
except in Dimapur.
But now this seems to be in violation of the
Yeah.
Registrar General case. So notice was to be issued, then subsequently the state withdraws this notification. That means the rule has been deleted already. Rule has been repealed. When a criminal side of the rule is repealed, then how can the other side of the civil justice be retained? There will be inconsistency. Now, if we are to go by the judgment of the learned this Registrar General's case, we need to have three courts. I mean, three tiers of judicial system. One, customary court. One, executive officers court under the rules. One, regularly constituted courts manned by the judicial officers. We have three. Now, we are in this mess, Your Lordship. But by implication, if you have to follow the Arunachal's steps, the rules is repealed by implication. Then in the case of Nagaland law, it should be. And the existing cases should stand automatically transferred to relevant regular courts, not under the rules. And in the meantime, if the government constitute or enforce Chapter 4A, we have no problem. It's okay. But now, where do we go? It is not only these two cases. There are several cases pending in bench because of this issue. They cannot further proceed. So, if the rule is not repealed by implication, and in the absence of a customary courts, we have to follow the old rules, appealing to civil judge senior or district assistant judge. That should be permissible. Otherwise, the problem with the executive officers is they have no legal knowledge. Now, in case of documents, when a document is alleged to be forged or not admissible under the Registration Act, the executive officers cannot deal with that. And the other problem is filing of appeals. They process the matter as if they are processing other office files. They'll put up, they'll go to somebody, another, it takes several days. And are they in any way have better knowledge with the customary practices in Nagaland? I believe judicial officers have better knowledge in customary practices, not the executive officers. And even if other regular courts, not only in Nagaland, everywhere else, Your Lordship knows, where customary practice is not against public policy, certainly a regular course and for such customary practices, there is no bar for that.
Yes, state, what do you have to say?
Lordship, I have a instruction for the Department of Law and Justice in regard to these two matters.
In fact, Mr. Iralu, this time I was going through the new BSA Act, the Bharatiya Saksha Adhyayam, which is taking over the Indian Evidence Act. One very important aspect which you had earlier in the Evidence Act, Section 45, now it becomes 47. The very interesting part is earlier it was said art, science, expert witnesses. Now it has also been brought in or in any other fields.
Yes.
This is a very important aspect when it brings in any other fields. Just for example, a customary thing. Now, these can be now given evidence to the effect.
Yes.
Very well.
Yes.
Earlier it was that whether this custom, how it is to be treated, you have to take some books and all these things. But now a person, just for example, who is just shifting in a particular village or a particular, he can very well give evidence and he may become now an expert evidence.
Yes, yes.
This is the new amendment which is coming.
I see.
Your Lordship, if the appeal is from the decision of the village council is under the 1937 rules, then it must go to the TC and its assistants as per the Rule 31, because provision is there. And so far as if it is comes under the provision of the CPC, then it must go to the judicial officers considered under the states.
So you support the view of Justice A.D. Chaudhary, to the effect that there will be two parallel proceedings.
There is two parallel, 37 proceeding is quite different because it speaks about DC and its assistant and the village court. And as my learned senior friend has said, chapter 4, rule 39 has not been given effect to by the state. So decision of the village council, if it is under the provision of the rule 37, it must go to the DC and its assistant as per the 37 rules, rule 31, rule 31.
So in other words, if there is an order being passed by an authority coming under 23A or 24, 23 is gone, that cannot happen. So 23A and 24, it will lie to under 31. That is here.
Yes.
Your Worship, another submission. Now, we cannot have two regular parallel courts. If it is customary courts under chapter 4A, it will be totally different. But under the rules, since the rule must give way, if we have two parallel courts exercised by one by the executive and by the judicials, they will be inconsistent with the decision of this. We'll be having two parallel courts.
And what do you say about those judgments in the Supreme Court earlier, modern Indian caterers, where there are two parallel courts, where a person has the authority or the government or anybody has an authority to initiate, one may file here and one may file the other way. Then in that two remedies being available, one remedy says about the limited score, evidence or nothing to that effect. It's a viva voce in as per Rule 26. On the other hand, one person has to go for a full length with Evidence Act, everything being come into play. Wouldn't that have a discriminatory or an arbitrary aspect?
Certainly it will be there. It will crop up. Now, if we follow the present system, the alleged system as submitted by my learned friend, government advocate, there is no provision whereby the executive courts can deal with customary law, even under the rules.
See, more, the issue is, we have made an amendment saying that the village council will be the village courts. And the
Lordship.
appellate authority would be the district subordinate for customary courts.
Lordship, may please,
And the appellate,
appellate court,
no, under rule, under chapter 4A. Now, you are saying 4A is not made applicable.
it does not give an effect.
Then on what basis have you made that?
Lordship, what I'm saying is, Rule 31 has, Lord, the stand up the state, Rule 31, your Lordship. Yeah, I read your Lordship, Rule 31. An appeal shall lie from the decision of the Mazadar, Convera, Chief, Headman of Hills, Dobashis, or other duly recognized village authority to the tribal court, whatever considered or otherwise, to the deputy commissioner or his assistant. A record shall be made of the matter and dispute in the decision of the village authorities. If necessary, the court shall examine the parties, and if the decision of it to be just, shall affirm and enforce as it is one of its own. If the court sees reason of doubt to the justice of the decision, it shall try the cases de novo or refer it to a panchayat as ever. In this case, your lordship, our state cannot give a proper things. It is up to the wisdom of this honorable court to decide. Lordship may kindly come to page 57. The order which is under challenge passed by the principal district and sitting judge. And civil revision number 5.
One thing, the Register General judgment categorically says that the rules of administration of justice would give away to the Civil Courts Act. How do you take care of that? It's the mandate of the judgment. Paragraph 32, the last portion.
Lordship, para 32.
The last sentence, the administration of.
It is thus clear that if the legislative intent is to bar applicability of CBC and service it to the customary courts or courts made by the executive officers, the said bar cannot be held to be applicable to regular courts. This interpretation will be harmonized with the functioning of regular courts under the Civil Courts Act and also customary or executive courts under the administration of justice rules. Accordingly, we hold that the Bengal, Accra, and Assam Civil Courts Act 1887 is applicable to the districts of Timah Hesau and Kabrianglong in the state of Assam and the state of Arunachal Pradesh and Nagaland. The administration of justice rules applicable in the state of Nagaland and the Northeast Frontier Administration and Justice Rules 1945 applicable in the state of Arunachal Pradesh will give away to the provisions of the Civil Courts Act to the extent of inconsistency in relation to the function of the courts made by the members of cadre of judicial service.
So what do you say?
The Lordship will respectfully carry out this any order which is passed by the Honorable High Court.
Because what Mr. Iralu has also pointed out, Mr. Jami has also pointed out one thing. How do we take care of a very recent amendment being made in 2022? She has pointed out. Now, on one hand, you are not having a village court. You have not brought in chapter 4A. And on the other hand, you are trying to go for a separation of the executive and judiciary in view of the Register General's court judgment.
Lordship.
And on the other, again, you are trying to incorporate the village court. And above that, there is an appeal provision, that means you are again that village court, an appeal normally would have lied because the village court is the customary court. And against that, appeal lies under 31. So without amending the rules of 37, you are again trying to take away the right even of the DC also by having the appeal provision there, inserting another deputy subordinate court. How are you taking care of that? If it is the intention of the state for a bifurcation of the executive and the judiciary.
Lordship, to take care of that, your query, I don't have this proper instruction in that regard. So I'm not in a position today to satisfy your Lordship's query.
But Mr. Limar, then the counsel for the appellant in civil division 5 of 2020, as well as Mr. R. Iralu, then a senior counsel, assisted by Mr. M. Iralu, then counsel to the appellants in civil division 6 of 2021. Yes. Stop. Considering the intricacies involved in the present list, we request the Learned Advocate General to assist this court by the next returning date. When can we have you?
I have to seek when you will be free, your Lordship.
You can very well appear through video conferencing. We have no problem with that.
I was told he's appearing on Friday. London AG is coming to Kohima tonight, today. So maybe on Friday, Your Lordship.
We'll have it next week.
If he's arriving today, then it can be taken up tomorrow or.
He will require some preparation also.
Will require some preparation.
Otherwise, when the matter was taken up last time, AG came.
We'll have it on 19th. If he's not available, he can join us by BC.
Oh, Lordship.
Bless you.
We're ready. I'm for 12. Dah.
For hearing, item numbers 12 and 13.
May I please, Lordship? My Lord, I am in criminal appeal number 6 of 2020. 6 of 2020, my Lord.
And what about the other one?
The other one, she was present in the morning, but my matter can be separated if she is not around.
It's the same matter, isn't it?
Similar,
From the same judgment.
Same judgment.
Then we have to hear her.
Otherwise, it will hardly.
This is that NTPS.
Correct. It will hardly take 30 minutes to finish because question of law only.
Just check up that.
Yeah, that's fine.
You are alleging violation of section.
Basically, 3 things. One is non-compliance of section 52A, which is mandatory. Inventory lease is not prepared. There is no certificate from magistrate, so that is one. Secondly, while we screen through all the judgment, the only relevant page was paragraph 15. Nowhere it is shown that these articles were exhibited in the court. 2. Number 3, I have so many points, but third things is there is no independent witness at all, though he was arrested from the village. So, basic things. So therefore, my submission will be hardly 30 minutes only. Oh, otherwise, she was in the morning.
Yeah, she was there.
Otherwise, only purely question of law. The seized article were not exhibited at all. There are 5 exhibits. No way it is from the judgment itself. Nothing. So therefore, I have made it that the conviction order is bad in law. Yes.
Then we'll fix a date.
Can't help you if she's not there.
But is all under counsel for the appellant in criminal appeal number 6 of 2020, as well as Mr. K. Anganga, Leonard Yardi, public prosecutor. None appears for the appellant in criminal appeal within bracket J 4 of 2020. When do you want?
My Lord, in that case, after 2 weeks, because I may be out of station for my daughter's checkup once.
This is the matter after 2 weeks.
If it is today, fine, but if it is not today.
You are the village
Chairman.
Chairman.
Yes.
And the second appellant is the.
That is another from another village who allegedly brought ganja to my house. No seizure was exhibited. 52A was not complied. Independent witness, though it was from the village, no one was called to witness.
In fact, Mr. Joe, last time me and Justice
My Lord.
exactly on the same.
Exactly, my Lord. Lordship has pointed out that. So just question of law only. That's why I thought it will hardly take 10-20 minutes only.
No.
Separate matter, my Lord.
Disposed of one.
Yes, one matter. Another matter. And case is far better than.
Are you sure?
100% this, at least on question of law. Question of law.
In fact, a recent judgment has also come. From, I think, our earlier Chief Justice.
Bob Day.
No, Justice
Sandeep
Mehta. So he was there. He
Yes.
delivered the judgment on 52A also.
क्या रहा है?
Itu tuh semua cang, saya cang, semua. Macam apa?
लड़की है समझो ना लड़के अच्छा
Semua cang.
Silakan kami dari